testing.
Test. No. Sounds like it is, but it's not. The lights are on, but okay.
Good evening. This meeting will come to order. This is the Zoning Board of Appeals, December 2023 meeting. Let's begin with the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Roll call, please.
Ms. Ferrante. Here. Ms. Hirsch. Here. Mr. King.
Here.
Mr. Montano.
Here.
Mr. Soto.
Here.
And Chairman Tizzola.
Here. Also present this evening are Stephen Harris, our zoning officer, Meg Green, our recording secretary. Let's see, for your attention, welcome this evening Andrew King. Andrew is new to our zoning board. Mr. King is filling in the vacant alternate position till it expires. So, if you feel there's a commissioner on this board that might be a conflict of interest to your application, also let us know that. With that, we'll begin. Oh, hold on one thing. Thank you. Mr. Wolf is not here this evening, so Ms. Hirsch, will you please fill in for Mr. Wolf?
Yes, Mr. Chair. Item number 1, 72 Westport Place, MBP 85/924/1H, R30, Thomas Lynch Esquire for James Cottrell, owner, varies 3.1.4.1 south setback from 7 feet where 15 feet required for addition, east setback to 5 feet where 10 feet required for accessory structure, 4.1.1.1 front yard setback to 25 feet where 40 feet required for pool, 4.1.4 front porch projection to 5.8 feet where 4 feet permitted, 4.1.4 rear deck projection to 6.3 feet where 4 feet permitted, 4.1.5 terrace projection to 8.9 feet where 15 feet permitted in front yard. Survey, Codis Bodie and Associates, 7/25/23, revised 9/20/23.
Good evening, Mr. Chairman, members of the board. Hopefully this is working. I can. That one is. All right. Again, just for the record, Thomas Lynch, my law office is located here in Milford at 63 Cherry Street and with the law firm of Lynch, Trimbicki, and Boyden. And I'm here tonight with my client, James Cottrell. Jim, in his wife Patricia are the owners of the property at 72 Westport Place. And as Sarah noted in the reading of the application, we're before you with a request for a number of variances pursuant to Section 3141 and Sections 4.1.4 of the zoning regulations to allow an addition and renovations to the existing single-family residence. Now, the recitation of variances is a mouthful, I will admit, but I'm going to be going into some arguments to show you that because of the shape of this lot and the resulting setbacks that are because of the configuration of the lot, that necessitated for the additions that are envisioned here, these requests for the variances. Most of them are pretty minor in nature in terms of size. There's an existing 2,600 square foot house on site that was built by Ron Standish back in 2000. This particular lot was a lot on a subdivision map known as Oronoque Meadows that was developed by Ron Standish and Greg Field back in 2000. And at that time, they built this house for Jim and his wife. So the existing house has 2,600 square feet. It has a two-car garage. The plans submitted to you envision the demolition of the existing garage and having a in-ground pool on that northerly portion of the property with a portico serving as an arch leading to the driveway to the back where Jim wants to build a detached garage in the rear. Now, the one thing I do want to say about the garage in the rear, that portion of the property borders on the open space of Lexington Green. So if we recognize that one of the purposes under our zoning regulations is to create spacing between properties so that you're not infringing upon your neighbor's privacy or having a dwelling that overpowers the neighbor's use of their property. I submit to you that in this case, these lots at the end of the cul-de-sac on Westport border on the open space of Lexington Green, so there is a very large area between my client's property and the homes to the rear of Lexington Green. So I think as it relates to the garage, that's an important point to stress to you. As I said, that garage is going to be demolished, and the additional garage and pool would be in that portion of the property. The other thing that's of note here is that in the year 2000, this subdivision was approved under the cluster subdivision regulations. So that you know the concept of a cluster subdivision, you have open space that's dedicated because of the existence of wetlands or some other topography issue that doesn't allow development in that portion of a property. And under the cluster regulations, you can then have smaller lots as long as you have a portion of the area dedicated as open space. When Standish and Field went before the Planning and Zoning Commission back in 2000, this was approved as a cluster subdivision, so that these lots, even though they're located in zone classification R30, they were approved, or the subdivision was approved with the cluster, so that you could then have lots that could be 18,000 square feet and conform to the setback requirements of 18,000 square feet. So I think that's noteworthy because other similarly situated homes in the area have to conform to the R30 zoning regulations in terms of lot coverage and setback. These homes have to comply with the R18 setback requirements, so that the plan laid out for you and the Codispoti map showing the dotted area, which is the setback areas where you can build, those are based not on the R30 but the R18 regulations. And as I said, between the bedroom addition on the south side of the property, the small addition to the kitchen that's attached to the driveway portico, and then the front porches, there's only a total of 1,000 square feet in additional living space that's added to this house. So even though you look at Jim Deno's elevation view and it looks like a massive-looking structure. It really isn't. I think it's just the way that it's shown on the plan, and the fact that he had to basically wrap the front additions and the porch and everything to try to, as best he could, keep the home and the decks and the addition within the setback areas. But again, not overly stressing it. If you look at the map, see how it arches up in the front. It then follows a weird angle going back on the south side and the north side. So it was very, very difficult to try to come up with the additions as envisioned, because Mr. and Mrs. Cottrell, the purpose of the bedroom addition on the south side of the property is for their parents, Jim's parents, who have lived here in Milford for many, many years on Orange Avenue. The intent is for them to sell their house and move in with Jim and Patty. The last point that I wanted to make to you is this application appeared on your agenda over the last 2 months, and it was continued. And that was because we had ongoing discussions with Pat and Lisa Pacelli, who owned the residence to just the south of this property at 7 Beth Ann Circle. They had some concerns with the original plan that had a larger addition on the south side of the property. And when I say the south side, as you're looking at the map, it's actually the improvements going out to the left. And Stephen is running the cursor over that. So after discussions with Lisa and Pat and their attorney in my office, the plans were amended. That addition was reduced. It's now some 500 square feet. And the original request was to have that addition come within 7 feet of the property line. And it was redesigned, and I sent to Stephen and Meg earlier this week the revised Codispoti plan. And per the discussions with the Pacellis, that addition has been reduced in size. There's now just a 3-foot encroachment within the setback. So there's a 12-foot setback that's provided. The original plan had a 7-foot setback. And to evidence that, I submitted to you, asked Meg to pass among the board members a letter that I received about an hour ago from Ms. Pacelli's attorney, basically saying that they, as the owners of 7 Beth Ann Circle, have reviewed the documentation related to 72 Westport Place with regard to this application. Lisa, who is the title owner of the property, is in favor of the application, subject to the following stipulations, which we agree to have as part of any approval from the board tonight. A condition that the variance be as shown on the plans, a 3-foot encroachment into the setback, that the structure be limited to 1 story in size, and that the applicant plant evergreen trees known as green giants at least 6 feet in height on the border of the properties between the 2 residences. My client has no objection whatsoever to those conditions being made part of any approval. So that's it. I'm happy to answer any questions if you have them, and Mr. Cottrell is here as well.
The letter from Lisa Pacelli,
Yes.
are all these measurements reflected in what we're seeing up
Yes.
here right now?
Yes.
They are, okay. All right, commissioners, questions for attorney? Go ahead, Mr. Soto.
Attorney Lynch, Stephen, could you zoom in on that again? What is the 37 square foot thing on the next to the addition, 3 foot 6 by 10 6?
It's a hallway connecting the proposed addition to the main
Okay.
part of the house.
Okay. And how are you going to get access? Stephen, could you go to the 2-car garage in the back? How are you going to have access to that garage?
There's a proposed driveway that goes through there's a fancy French word that was given to it. I call it a portico.
Oh, it's going through, okay.
A porte cochere,
Yeah,
if anyone knows what that is. To me,
just
it's a portico.
yeah, it's just a covered,
It's a covered
Yeah.
arch, right?
like a carport, fancy word for a carport.
Correct.
Okay, that's all I have, Joe.
Mr. Chairman,
Go-
through you.
yes, go ahead, Mr.
Attorney Lynch, I
Montano.
have two documents here. I'm a little confused.
Okay?
The south setback on one sheet says 12, but our paper says 7.
That was the original,
Original
that was
was
the
12.
original request.
So we're
It's now
asking-
12.
It's now 12.
It's now 12. It's to vary the side yard setback to have a setback of 12 feet,
Okay.
and whereas 15 feet is required. So we moved the addition, shortened the addition so it moved back 4 feet.
Thank you.
Any other questions? No other questions, okay. All right, is there anyone else speaking in favor of this application? Anyone speaking in favor? Is there anyone here opposed to this application? Commissioners, no further questions? No? Okay. All right. This hearing's closed. So we need a motion.
I move to approve as presented with the following stipulations, which I'll read at the end of the proposal. The petition of Thomas Lynch Esquire for James Cottrell, owner, to vary section 3.1.4.1 south setback to 12 feet where 15 feet required for addition, east setback to 5 feet where 10 feet required for accessory structure, vary section 4.1.1.1 front yard setback to 25 feet where 40 required for a pool, vary section 4.1.4 front porch projection to 5'8" where 4 permitted, vary section 4.1.4 rear deck projection to 6.3 feet where 4 permitted, vary section 4.1.5 terrace projection to 8.9 where 15 feet permitted in front yard in accordance with the survey by Codispoti and Associates 72523, revised 9/20/23, including the following stipulations. Thank you. No greater than a 3-foot variance for the proposed 560 square foot structure on the southwestern side of the subject property closest to Lisa Pacelli's property line. This board will also limit the same proposed structure to 1 story, and the applicant is required to plant evergreen trees known as green giants at least 6 feet in height on the border of the properties to screen the new construction from Ms. Pacelli's property.
Mr. Chairman, I know the public hearing is closed, but just for administrative purposes, Ms. Hirsch read into the record a resolution to approve. It recited the Codispoti plans that were originally submitted, and perhaps it would be appropriate to have that motion say revised to the December 10th plans, or I believe it was, that were sent in, because the plans as stated in that resolution were revised to actually reduce the encroachment on the south side. Does that make sense?
I'm happy to revise my motion to reference Codispoti and Associates December 10th, 2023 plans. Thank you, Attorney Hirsch, Attorney Lynch.
We need a second.
I second it.
We have a motion to approve, and we have a second on the motion. Discussion?
Well, I think, it's been hanging around for a couple months before we actually heard it this month, but, Attorney Lynch negotiated with the property owners and, they came up, so I don't have a problem with this. As long as the neighbors are happy, there's no opposition to it.
Any other comments? We have a lot of variances here. We're all set with everything?
Well, the hardship is the size of the lot and the angles of the lot and the cul-de-sac and the circular dimensions and everything.
Okay, any other comments? Before I take a vote, any other comments? Okay. Mr. Soto, your vote, please.
With the motion.
Ms. Ferranti,
With the motion.
Mr. Montana,
With the motion.
Ms. Hirsch.
With the motion.
I'm with the motion, it's approved.
Thanks very much.
Item number 2, 15 Bonsaline Street, MBP 71/778/5, R5, Kevin Kersaden Esquire, owner, appeal the decision of the zoning enforcement officer in accordance with the provisions of section 9.2.1 regarding issuance of zoning permit that allows increase in non-conforming structure and non-conforming building area as percentage of lot without required variances. Structure exceeds approved variance. Variance expired.
Good evening, Mr. Chairman. For the record, my name is Kevin Kersaden. My office address is 3 Lafayette Street here in Milford with the law firm of Kersaden and Moore. My home address is 11 Bonsaline Street, which is adjacent to this property. I'm just trying to see if I can share my screen as I go through this. Okay. By way of background, and originally there was a variance approved in 1983 for a one-story, one-car garage. And I'll show you those. I don't know why this Zoom thing. So this is the original plan. They didn't have a survey, or they didn't present a survey at the time, and it shows this proposed garage addition 3 feet off the property line. This garage is 13 and a half feet as shown on those plans, this proposed garage. I'm just giving you a little bit of background, then I'm going to focus on 3 main points. So this was the original elevations that were approved with that variance. Single story, single car garage, and you can see down in the bottom right-hand corner it says, something, I think June 1983. Those are the plans received or approved by the ZBA. This is the side elevation of those same plans. So it's important to note, as part of my objection for the reissuance of this zoning permit, and I apologize, I'm not sure why this keeps popping up there, that these dimensions are the width of the garage that was actually built is about 13 and a half or 13.5 or 13.6 or 7 feet. And the reason I'm bringing this up is because I did not, in 1983 file this variance, and I did not submit the zoning permit sometime last year or earlier this year, stating that the proposed structure was supposed to be 3 feet from the property line. That was the property owner or the design professionals that submitted that. Here's a picture of the structure as it's being built. You can see that it's close to there's a fence there. The fence is 3 feet or 3.1 feet, I think, from the structure. And this structure is at some points a little less than 6 feet from my house, which is the house, the blue house on the left of the picture. This is the rear elevation of it, and this is the side elevation of it as you come back off the back. My point being, with respect to and I'll get to this zoning table in a minute, is that this property owner, her design professionals, determined that that was the property line. They determined that was the property line when they applied for the variance in 1983. That variance was approved. After that, they confirmed that they believed that that was the property line. When they came in for the permit originally, they did not present a survey. I actually reached out to Mr. McElroy at that time by email and a phone call and said, hey, you should get a survey of this lot. to make sure that you put the foundation in the correct place because it's pretty tight over there. I think we might have had one exchange of communications and then the communications stopped between he and I. For whatever reason, they weren't required to present a survey when they came in for that original zoning application. After I reviewed the file originally, I think it was in the springtime, the only thing that was in the file was the variance approval, which I think Stephen's going to present, that application, and this plan. Those elevations that were approved were not in the file. So, in fairness to Stephen at that time, he doesn't know whether they approved, well, it's not in the file. I went and looked at the file. This was not in the file at that time. So he doesn't know whether it was a, one-story garage, two-story garage. So he issued a permit at that time based on the variance for a two-story garage. A couple of months went by, and I happened to go back in and look at the file again, and then I found that these plans were now in the file, hanging at the bottom of the file. So I notified Stephen and Joe, and Joe Griffith, Director of Permitting and Land Use, and they determined that that permit was not in compliance with the approved variance because it was 2 stories and not 1 story, which is in line with traditionally how they interpret the enforcement of and use of variances now, these days. So fast forward, I think I don't know if they revoked the zoning permit or the building permit, or they put a stop work order in effect, or what have you. And I believe they told the property owner and her design professionals that they had to obtain a survey because she was potentially going to have to come back in for another variance for the 2nd story of this structure. So I guess we waited. A survey came from Codispoti and Associates, and it showed that the property line was actually according to the Codispoti survey, which I don't disagree what it says or what it shows. It shows the fence. It shows the fence encroaching on what Joe Codispoti determined was the property line pursuant to his survey. The issue I have so they brought this survey into Stephen and the zoning department, I believe, and they said, oh, well, you don't even need a variance at all now because now it's 5 feet from the property line and the side yard setback's 5 feet. But the issue is, so once I found out that this was what the supposed property line was, or what Joe Codispoti has as the property line, I filed an adverse possession claim because this fence has been there for about 30, 40 years, or some fence like it, because there's another survey in the land records in 1989 that shows this fence there in this exact same location, or very close into the same location. My point being is that the adverse possession claim, one of my first points is that the adverse possession claim should be determined before it's determined whether a variance is required for the 2nd story of the structure or not, because that was their property line that they relied on in order to get the original permit, and that was the property line that they relied on when they got the variance. So that's my first point. My second point is that the existing survey, and this one I really don't understand, because I've had clients in similar situations and they've been required to remove square footage in order to comply. This existing survey, or the current survey, shows the building area as a percentage of the lot at 41.7% when 40% is required. Now, there's no variance on record for an increase in the lot coverage. I had a conversation with Stephen at the time when I saw this survey, and I said, well, they at least need a variance for that lot coverage, even though it's a de minimis. Some may claim it's a de minimis amount, it's a minimal amount. It's still over the zoning regulations, and there's nothing in the records that show that a variance was granted for it. And I think Stephen's reply was kind of like, well, you know, we don't know what was in existence back then and, you know, when they got the variance, so we're just going to assume that, you know, they had that coverage, or I'm paraphrasing, but it was something to that effect. So at the bare minimum, they need a variance for the lot percent of the building area as a percentage of a lot, or they need to reduce the square footage of the lot in some way, shape, or form. If they, like for example, on 125 Ridgewood over in Morningside, I had a client that even though he had like 60% coverage, and even though he was reducing some of the coverage, and it was legal pre-existing non-conforming, in order to get his certificate of occupancy, he had, because his site plan showed a certain, like 48%, he was required to cut back some of the pavement. So it's not unheard of for that to be done. My other point is that this is an illegal expansion of a non-conforming structure in violation of Section 6 of the zoning regulations. The plans as approved by Stephen as part of his site plan review for the process in issuing the permit, they don't show any lighting on the front of the structure, and I have got a light meter reading. The light regulations require that the foot candles be no more than 0.1 foot candle on residentially zoned property on the border or on the property line. And I had a light meter done with, I can show you the type of light meter that was used, and the foot candles are actually 3.0 foot candles on the property line. So it's extremely bright, streaming into one of the bedroom windows. There's the type of light meter that was used to register that, and that was taken, one of the readings was taken last night. So I think what Stephen will say is, well, we don't review lighting, or I think he said in his comments, in his memorandum, that the light, there's no light complaint. Well, there's been a light complaint since I filed this appeal. I would consider that a light complaint, but he'll probably also say that you don't need to, he doesn't need to review it, because that section only comes into play when you have a site plan application. But when you read the plain language of that section, it actually says that this regulation of outdoor lighting applies to both permanently installed outdoor light fixtures and temporary, and is necessary to prevent misdirected or excessive artificial light caused by inappropriate or misarranged light fixtures that produce direct glare, light trespass, and so on and so forth. And then, you know, you go down and look in section 5.2.3, it says light trespass. All light fixtures shall be designed, installed, and maintained to prevent light trespass as specified in the following sections, which is the 0.1 foot candle, and it's way over and above that. I want to comment briefly on Stephen's memorandum, because I agree with some of it, and then I disagree with other aspects of it. And I also think respectfully to Stephen or the City Attorney's Office, I'm not sure if they helped with this. It's contradictory. So Stephen has the summary of facts and procedural history. I agree, you know, the variance was recorded. That was one of the other points. I think that there's a misconception that variances do run with the land. That is correct. Variances run with the land, and the reason for that, the language in that statute, is so that it's clear that a variance does not expire when property ownership changes. But variances there's nothing in Section 8-6 of the Connecticut General Statutes, which is the guiding statute for the Zoning Board of Appeals, from which all of your jurisdiction and authority and power flows. And if it's not in the statute, you don't have that jurisdiction or power, or it doesn't apply to you. So for example, there's nothing in that statute that says that a variance can't expire. And if you look in the record, and I'll show, this is the original approvals. This, I think, is the original expiration. Milford used to have a regulation back then, 39, or 40 years ago, when this variance was originally approved, that they would expire after 1 year. So here's an extension letter in June, granting them till June 1985 to complete the variance. And so why would that be? Well, it would be because if you wait 39 years to utilize a variance, a lot of things change in that time frame, which is leading to part of the problem that we're having now. So for example, we don't know what's changed on the property in the past 39 years. We don't know, especially since there was no survey in 1983, whether the property's changed in size. We don't know Stephen doesn't know what was on the property in addition to the house. I don't know what was on the property, so we don't know the total. That's part of the issue with the total lot coverage. So I think there is a valid argument that this particular variance expired. And I understand what the statute says, but the statute and the case law go to the protection of a variance from one property owner to another. You can still have conditions to variances. You just granted a variance tonight with several conditions to it. You can have a variance that expired. So I think that this variance expired. Stephen's correct on his point number 3. The zoning permit was revoked, I believe, because the scope of work exceeded what the ZBA approved in 1983. That's correct. It was reissued based on that recent survey. And again, my point is that the actual property line should be confirmed, and in this case, unfortunately, it's going to have to be confirmed either by agreement or by a court of law about where that property line is. But this property owner has on several, or their predecessor in interest has on several occasions determined that the property line is the line that's 3 feet from the structure and should require a variance. So if it should require a variance, that second story needs a variance. I did take this appeal for those reasons. I just talked about them briefly. I do agree with the city's position, number one, when a variance is granted and recorded, that the materials that comprise the record cannot be amended after the fact. I don't know what that has to do with tonight. That's not what I'm asking for. Or the variance revisited to see if further revariances for the project are required. That's not what I'm asking for. And this is something that's, I think, completely out of context for what we're talking about. No one's asking to go back and revisit that variance to see if further variances for the project are required. What I'm saying is that when they pulled the permit, this current survey shows that there's that the result of the construction of this new garage has put it over the square footage. That's not going back and asking you to revisit the variance. Stephen, this bullet point almost makes it seem like they approved that variance for the lot coverage back in 1983, and there's nothing in the record that says that lot variance was approved in 1983. Yeah, I don't know why they didn't have a survey in a zoning table back in 1983, but they didn't. As a matter of equity, the board is required to honor the past approval. Okay, you can honor the past approval, and if that's the case, it should also honor the property line that approval was based on, not a property line that was been newly established today and is up for dispute, because if the structure is allowed to stay as is without a further variance for that second story, at this juncture, the property line, if I'm correct, and the adverse possession claim or the quiet title claim is correct for the encroachment of that fence, now we have a structure that has a second story that does not have a variance, and it's totally non-conforming because it's less than 5 feet away from the property line. So I think that case should be decided, or that some settlement, whatever would happen along those lines, before before the zoning permit reissues and before a CO is issued, because once that's done, then we have that issue with the property line after the fact. And I think I am correct. Otherwise, I'm not wasting my time and money. bringing this application because I do think I have valid claims. I do want to point out that I did try to reach out to Mr. McElroy, like I said once before. I did want to try to have some kind of discussions before bringing appeals and bringing lawsuits, but I wasn't able to. No one's asking the city to decide further variances are required for the structure as far as the setback goes. What we're asking for is that the variance be enforced and that any additional variances that are required for the property be applied for. And that's the problem when you wait 39 or 40 years to take action on a variance and build a structure. So now maybe there was a shed there before on the side of the house, the right side, or the left side, and the back side that had, maybe there wasn't. We don't know, but what we know right now is that it's over the lot coverage, and there definitely needs to be a variance for that. And maybe the light trespass is a separate complaint. I can file that complaint now, put it on record that there's a complaint about that. So the conclusions here, I agree, a variance was recorded to build a garage. It was recorded, and the variance is protected. It's protected from property owner to property owner, but it's not protected in perpetuity unless somebody takes some kind of action on it. That's my position. The property owner relied in good faith on that approval to construct the garage. I disagree with that because what the property owner did was they constructed a two-story garage when a one-story garage was approved. And it says which was built to the same size as shown on the approved variance of 1983. It was built to the same footprint. That's different. And I don't have any problem with a one-story, one-car garage. And I'm in here for applications opposing things or trying to get things approved. I understand things need to be built. I don't have any problem with that. My issue is the fact that it's 2 stories. It was approved as a 1-story. The permit never should have been issued in the first place. The property line, that's not my property. That's not the property line that I claimed. That's the property line that they claimed in the variance, and that's the property line that they claimed in their initial permit. And now after the fact, oh no, that's not the property line. This is the property line over here. Here's our survey, finally. After 40 years, we have a survey for this property, and now we want you to allow us to keep this 2-story structure, which was built as a supposed stair pull-down attic for storage space, which the first level is like 10 to almost 10, 12, 15 feet off the elevation. So it was never intended to be an attic. It's a tremendous amount of money to spend on an attic. It's always intended to be living space, is my position. So, I agree with Stephen's concepts, but I don't agree with the analysis and the interpretation of the facts in this case. And I'll, just for, final clarity, 8-6, as far as the expiration goes of the variance, any variance granted by a zoning board of appeals shall run with the land and shall not be personal in nature to the person who applied for and received the variance. There was issues with boards claiming that variances expired when property ownership changed, and that was not the intention, and that's what this statute amendment was designed to reflect. It shall not be extinguished solely because of the transfer of the title to property or the invalidity of any condition attached to that variance that would affect the transfer of the property from the person who initially applied for and received the variance. I don't see anything in there that a variance can expire. So, pending your questions, that completes my argument. Thank you.
All right, questions for Attorney Crusaden? Go ahead, Mr. Soto.
Okay, so Attorney Crusaden, you're saying that the variance was taken out with a 3-foot setback, and then when the survey came in this year, it's actually 5 feet.
That's what the survey shows,
Now,
correct?
do you have a survey for your property?
I am in the process of getting that
Okay,
finalized.
so that's what I was going to ask you, if the numbers matched.
Yep.
Because that would be the first thing we'd want to look at, you know what I mean?
Right.
So back in '83, there was a one-year expiration on the variance, correct?
That's what it said, yes.
So what year did they remove that 1 year and go and get rid of it?
I don't know. Probably when this statute was amended, whatever, to possibly, I'm not really sure. I don't know.
Now, if it is 5 feet and it's attached to the house, they really don't need a variance for the second floor, do they?
That's correct.
Okay.
But my argument is that they said it was 3 feet from the property line. When you look at and they got the variance for it based on that. So I think that the previous property owner who got the variance, and up until now, they were forced to get a survey because they were issued a stop work order or the zoning permit was revoked. Now it's 5 feet, but all along, they said it was 3 feet. So all I'm asking is, let a judge decide, or let's come to a settlement agreement about what the true property line is. Because if it's where Joe Codispoti says it is, I can't access my gas or water. It's like 18 inches off the side of my house.
So what do you have now from your house to the fence that's there now? How many feet do you have?
From my house to the fence, at one spot, it's like I think it's 18 inches. And then it kind of like wanders. It's like 2 feet, 2.5 feet.
So where it's 18 inches, your house is actually on their property then, right?
No, it's 18 inches from. It's very close. Yeah, there's a spot where it's very tight in the back. Yeah.
Okay.
Yeah.
Any other questions? All right, is there anyone else speaking on Attorney Crusaden's position on this appeal? Okay, go ahead.
Sorry, thank you.
Attorney Crusaden, the
Yes.
3 foot, 5 foot line you're talking about, that's coming from the first floor garage, not the overhang?
Correct. Yeah.
All right, is there anyone else speaking? Hold on, sir, hold on. Anyone else speaking on Kevin Crusaden's position? All right. Mr. Harris, would you like to speak before this attorney speaks?
I can let Mr. Willinger go first if, okay. All right. Good evening, Stephen Harris, Milford Zoning Enforcement Officer. You have before you my memorandum, but I'd like to read it into the record and then walk you through the various documents. So, summary of facts and procedural history. One, on June 24th, 1983, a variance was recorded to reduce the side yard setback to 3 feet and to build a garage 13 and a half feet by 23 feet attached to the house. The attached garage was a one-story building. 2, on 9/30/22, a zoning permit was issued based upon the site plan submitted to the ZBA in 1983 to construct an attached garage. 3, on 7/25/23, the zoning permit was revoked because the scope of the work exceeded what the ZBA approved in 1983. The garage had a full second floor, which was not shown on the approved plans. 4, on 11/2/23, the zoning permit was reissued based upon a recent survey that showed the garage in a zoning compliant location. Since it was in a zoning compliant location and attached to the house, a second story was permissible. The building footprint remained the same size as the ZBA approval. 5, on 11/13/23, an appeal was taken for the reissuance of the zoning permit based upon section 3.1.4, section 6.3, section 5.2, and for the expiration of the variance. City's position: 1, section 3.1.4 and 6.3. The granting of the variance in 1983 was based upon the submitted materials. Scaled elevations were submitted, but a survey, including a zoning table, was not submitted. When a variance is granted and recorded, the materials that comprise the record cannot be amended after the fact or the variance revisited to see if further variances for the project are required. If in 1983 the ZBA wanted a survey and a zoning table, it would have asked for one prior to making its decision. Furthermore, as a matter of equity, this board is required to honor the past approval. The property owner relied in good faith on the approved variance. The city cannot now, after 40 years, decide further variances are required and force the property owner to file an application in order to build the same garage that has already been approved. Number 2, Section 5.2, the city is unaware of a complaint about light trespass, but we will look into that. 3, expiration of variance. Variances run with the land and they are not time limited. Once recorded, a variance is activated and never expires. I'll expand upon that later. Conclusion, 1, a variance was recorded to build a garage. The property owner relied in good faith on that approval to construct the garage, which was built to the same size as shown on the approved variance of 1983. 2, the ZBA has no authority to re-examine a recorded variance to see if additional variances are required. 3, as a matter of equity, the ZBA was required to honor the approved and recorded variance. For these reasons, I ask the board to uphold the decision to reissue the zoning permit. Now, Attorney Crusaden raised some issues. One concerning adverse possession. Adverse possession is not germane to this case. This board has no authority to hold that as some sort of matter it should consider in rendering its decision. That's a matter for the court. 2, the ZBA has no authority to determine if a survey is accurate or not accurate, or if this survey is more accurate than some other survey. 3, I'd just like to add in, the only survey that's in the record is the one submitted by the applicant to build the garage when I reissued the zoning permit. Concerning Connecticut General Statute 8.6, 8.6 does not provide a mechanism for variances to expire. It doesn't talk about that, but it also doesn't provide, it doesn't say they can't expire, but it says they cannot. It doesn't say they may expire. It's completely silent on it. If the General Assembly wanted variances to expire, they would amend 8.6 to include such language. For instance, variances that aren't put into effect after 5 years shall expire. There's no such language in there, so therefore variances do not expire. Again, just to reiterate some of the basic facts, the only survey is the one that the applicant has submitted. I'm going to open up the original set of plans. This was the original certificate of variance, and it's simply to vary the side yard setback from 5 to 3 feet. Again, you've already saw this. This is the original plan. It's not a survey, but the board in 1983 went with this. And it's the garage, it's the existing house. You notice it's 1 story. That's just the same thing from a different angle. No, not that. All right, so this is the reissued survey. Zoom in a bit. Here's the house. This is the little mudroom connecting. This is the garage. It's 13.5 by 23. It's 5 feet away, 5 feet away here, 5.1 feet away there. This is a conforming location. If you get a variance, you don't ever have to use it. They could have put this 3 feet away, but then they would have had to reduce the height down to 1 story. But they're putting this in a zoning compliant location. Now it's attached to the house, it's part of the house. It can be 35 feet high if they feel like it. But this, they want this little 2-story. And here, excuse me, these are the plans. Here's the house, the garage. You saw the photographs from Attorney Crusaden. So the bottom line is, 40 years ago, the ZBA granted an approval for a 13.5 by 23-foot garage attached to the house at 1 story. This board has no authority to revisit that. The property owner has every right to rely on that approval to build a garage of that size. They're on their own dime. They had a new survey drawn up. It turns out the garage is 5 feet away. It's in a zoning compliant location. They can put a 2nd story on. They can put a 3rd story on. It's zoning compliant. They can do whatever the regulations permit them to do. And again, just to stress again, this board cannot reopen that variance from 40 years ago. Because if you do, then you require a building coverage variance. The board can very well deny the whole thing. If you reopen it, you can deny it, you can approve it. You know, this homeowner already has an approval from 40 years ago. So you cannot reopen this and demand more variances. If the board in 1983 was happy with the plans they got, then that's the way it is. And I'll be happy to answer questions.
All right, any questions for Mr.
I
Harris?
have one quick. Stephen, so technically, based on that survey, they don't even need a variance.
No, they don't.
So the variance is,
I
doesn't
mean,
need-
it's there.
It's there if they wanted to make it bigger.
It's recorded.
Right.
It's recorded, and if they want to tear this down and build it to 3 feet, they
Right.
can, but then they'll have to lower the height to 1 story.
Right. So my other question, though, is you say they don't expire, but why did the board issue a letter in 1984 to give it a 1-year extension?
Zoning regulations have a very old regulation that say variances that are not taken advantage of within a year expire, and that is just flatly illegal. That is not provided for in law.
Sarah?
So they issued this expiration in 1983, but that was not valid?
No, that's not valid.
Other questions? Anyone else? Go ahead. Mr. King?
The 5 foot is coming off of the 1st floor or the 2nd floor? They have 5 foot of space off the 2nd floor?
Yeah, actually, the 2nd floor, let's go back to the,
You're allowed 20% setback.
actually, let me zoom in a bit here. So you're looking at it from just the garage door. So here's the roof, like this. This is basically a gigantic dormer, which is functionally, it's the 2nd floor. So this is pushed back a little bit. So the 2nd floor portion is even farther away, maybe like a half a foot farther.
And just to be clear, that the letter that said that it expired in 1 year, that is no, that was...
No, that is not valid.
That's not valid and...
Variances do not expire. It's
and
not
no
provided
longer
for.
done.
No.
And the fence, where the fence sits is not a consideration of this board, right?
The fence is, everybody thinks the fence is the property line. I've been in zoning for many, many years, and I rarely see a fence that's actually on a property line. They usually fall on this side or that side of the line.
All right, any further questions? Go ahead, sir. You're up.
Thank you, Mr. Chairman. Mr. Chairman, ladies and gentlemen of the commission and staff, good evening. My name is Charles Willinger, law firm of Willinger, and Busey, and I represent the owner who is most affected by this application, Susan Simone, who's here with her architect in attendance this evening. I represent Mrs. Simone in reference to that adverse possession lawsuit that the applicant has brought. And I don't believe that he has any chance of prevailing on that. Adverse possession takes 15 years. He has lived on the property about 6 years on his property.
My client and her now deceased husband have been living at the property in question for about a little over 20 years now. And the issue with the adverse possession case, as it affects this board decision, is that you can't rely on an allegation that the property line is that fence unless there's a court decision. So the only way that you have to determine what the real property line is, as we appeared this evening, is by an A2 survey, which has been prepared by Mr. Codispoti. And I don't know if you have the original, or if that would help you to look at it easier. Have you seen this survey? Okay, so may I approach? Codispodi's survey, and I'd like to point out to you that this is the property line, which is 5 feet off. You can see it says 5 feet off. The overhang doesn't count. There's a regulation that says the overhangs are permissible as long as they're 20% or 4 feet, so that's not any violation at all. This is an A2 certified signed survey, and it shows exactly where the property line is. Now, there is a fence that's closer to my clients to the west of the property line. There's a fence. And I want to tell you about the fence, but before I tell you, and you'll see that's closer to my client's house. Can I move over here? Okay, I want to make sure everybody sees it. This is the property line that's 5 feet, and this line here is the fence that you can see is a little closer to my client's property. Do you see that? Okay. And I want to just show you. I'm sorry. The same thing. Here's the property line, 5 feet, no violation. And here is the fence, that little line here. Can you see? And that's closer. So the applicant's position is, oh, I own up to the fence. But here's the issue with the fence. The predecessor entitled to the applicant had a son who was a paraplegic, and his access to his to the front of his house wasn't. And I should say, we had a fence right on the property line, and as a favor to that owner, because he was in a wheelchair, we moved the fence in its current location, where you have it now. We moved it closer to our house so that he could wheel around and get out to the front of his property. There is, and they know that, they did it, we did it at their request. And so once you ask somebody to move their fence, you can't then claim that I own that now by adverse possession, because you knew who the true owner is. So, and I don't want to get too technical, but the applicant, he's there 6 years. Technically, if the prior owner was there another, say, 9 years, you could stack that. So 9 plus 6, you could have adverse possession if the prior owner also claimed that land. But in this case, the prior owner needed our permission to use it for his wheelchair. So cannot be adverse possession, and he can't win that case. But for your purposes, you can't go on an allegation anyway. The only thing you could base your decision on is a survey. Now, there's no question, as Stephen and the applicant have said, that the prior, back in 1983, when the prior owners got the variance, they didn't have a survey. So they were operating on God knows what, but they weren't operating on actual evidence. We do have this survey. I think the fact that they got the variance, by the way, helps us with that 41.7% building coverage. I do want to say, though, I just tried a case about 6 months ago before both the Appellate Court of Connecticut and then the Supreme Court. And it was a case that talked about expirations of site plans and special permits. And everyone thought that a special permit lasted forever. And because of this case, it's been decided, no, special permits only last a very finite period of time, the same period of time as a site plan, roughly 15 years, 14, 15 years, depending on when it was granted. But in that case, both the Appellate Court and the Supreme Court cited several other cases which clearly show that variances don't and cannot expire. When they run with the land, they run with the land forever. And Stephen is 100% right. It's called black letter law. The applicant's wrong. Variances last forever. It helps us with the 41.7%. Now, let me see what else I could say. I'm not going to be here too long because I just found out about this application yesterday, actually. But the other things that I want to say, really, honestly, I want you to just do one other thing. I want you to take a look, if you will, if I could approach again, and you could pass this around. This is a photograph of the existing house, my client's house, and the garage that she's built. The second story, and you could see that. Now, that's an awful nice looking structure in a very nice neighborhood. And I'm not sure why, frankly, anybody would object to it. I don't know if it has anything to do with the strategy on the adverse possession case or not, but that's conjecture, I don't know. But I could tell you one thing. If the applicant is right, and if you were to sustain his position and rule against your zoning enforcement officer, there's a concept called municipal estoppel. And what that says is when a landowner relies on a permit from the city and to their detriment builds an addition, then if, for example, the applicant was right and we had to tear down that garage for some reason, the city is liable. And because they issued the permit on our reliance, it's called municipal estoppel. So we don't want to put the city in that position. We don't have to put the city in that position. Stephen is right, the applicant is wrong, and I would ask you, for all the reasons cited by Stephen and myself, that you deny this appeal. We're here if you have any other questions.
Any questions? No questions? Okay.
Thank you very much.
Mr. Crusaden, rebuttal.
Thank you. Yeah, just real quickly, Stephen's analysis and also Attorney Willinger's discussion about that prior variance helping with the total lot coverage, I don't follow that at all. I don't see anything in the prior variance about lot coverage. And Stephen's analysis saying that, well, you have to allow them to build it with this current lot coverage 39 or 40 years later. What if they had built other structures in the meantime? It completely ignores the fact that 39 years have elapsed and there could have been numerous changes to the property in between. And it also completely ignores the fact that there's no mention of any lot coverage as part of that variance in the first place. I disagree about the variances expiring. The case law that I've researched, and I've been wrong before, but the case law that I've researched discusses property owner to property owner. That's the reason for it. It doesn't expire when you transfer the property owner. And just because it doesn't say variances can expire in the state statute, doesn't mean you can't put conditions on variances for expiring. But once again, assuming I'm wrong about the variances expiring and I'm wrong about everything else, how does that help with the 41.7% versus the 40%? You can't issue a zoning permit, and don't be afraid about what Attorney Williger's, saying about municipal estoppel. That relies on the fact that an application was made in good faith. And the application that was presented, when they believed they needed a variance based on that property line that they've, for many years, said that that's the property line. And I'm not familiar with the fence being moved, but I do know there's another survey on the record that I had submitted versus via email from 1989 or 1990 that shows this fence in this same location. You can have tacking, like Attorney Willinger said, for the 15 years of adverse possession. Why does adverse possession matter in this case? Because it impacts the property line, and it's also, if I'm correct, it's the exact same property line that this previous property owner, up until they got a survey, or this current property owner, up until they got a survey, a couple months ago, believed that that was the property line too, based on all of their representations and actions to the city. So their application, when they thought they needed a variance, was for something far exceeding what the variance was approved for. And when I located that, or I saw those approved plans in the file, and I emailed Stephen and Joe Griffith and said, why are you allowing this two-story structure to be built when it was only approved as a one-story structure? I thought Joe Griffith was going to blow a gasket that they had issued that permit, because that's not how the city typically does things. That's not Stephen's fault that they submitted a set of plans and that for whatever reason, the previous approval documents were not in the file at that point in time, for whatever reason that was. So it's not an allegation about the property line. This is what this property owner said the property line was in their various applications. And Stephen says it's flatly illegal for a variance to expire. Where is the case law that says it's flatly illegal for a variance to expire? The case law I looked at, once again, talks about transfer from property owner to property owner. So at the bare minimum, they need a variance for the 41.7% versus the 40%, or Stephen just gets to decide, oh, I'm not going to enforce that part, I'll just give you a permit. So when I come in with an applicant and he's 2% over, I'm not going to need a variance? That's why this is important. If it applies to one person, it should apply to everybody. And that's all I have to say. Thanks.
All right. Any questions? No questions? Oh, Mr. Soto, go ahead.
I have a question for Stephen. So Stephen, what do you say about the 41.7% lot coverage? Do they need a variance?
This variance was decided 40 years ago, and the ZBA of 1983 could have asked for a survey. They didn't. They could have asked for a zoning table. They didn't. The homeowner has relied, his current property owners relied on that variance granted 40 years ago to build this garage. It's not up to this board to second guess what happened 40 years ago and demand something more. Because if you do that, like I said before, if you do that, you open the whole thing up again, you can deny the whole thing, and it's already been approved once.
Go ahead, Mr. Ferranti.
But to Attorney Crusaden's point, changes could have been made to the house between 1983 and now. When the variance was granted in 1983, they might not have needed a lot coverage variance in addition. And if changes were made and one is needed now, then that's not in the spirit in which the variance was granted.
That's speculation, and we don't know what ensued.
Well, we don't know, so shouldn't we have to address lot coverage now?
We don't know what ensued the last 40 years, and with respect, I don't think it's fair for the board to speculate this might have been built or that might have been built which pushed the building area above 40%.
But, sure, it's not fair to speculate, but I do think lot coverage needs to be addressed. Does it not? We're just going to ignore it because things may or may not have happened in the last 40 years?
If this was a fresh application, if none of this had happened 40 years ago and this property owner wanted to build a garage, and we looked at the survey, because we always get surveys and zoning tables now, and if it showed building coverage of 41.7, we would have added that into the variance ask. But like I said before, this was decided 40 years ago.
Mr. Chairman, just briefly in response to that, it is a fresh zoning permit application. So the zoning permit application, you know, if they had to come in for a variance or reduce the square footage or the lot coverage on their lot, that doesn't impact the previously approved variance, which was for the side yard setback. I mean, I almost, like, based on the number of years I've been working in Milford and dealing with variances and things, I almost, like, can't believe what I'm hearing from Stephen, that, well, we don't know what happened, so we're just going to give it to them. We don't know what the facts were back then, so we're just going to give it to them. They need a variance or they need to reduce the lot coverage. There's no doubt.
So the variance was for a 3-foot setback. It wasn't for a specific sized addition. So they can build a smaller footprint that would, that up to 3 feet, that then adheres to the lot coverage, can they not? And that's still respecting the variance and not bypassing the need for another one.
The scope of the variance is predicated on what's presented before the board at that time. Like,
But
for
what
instance,
was the variance? Was it
the first variance that you heard tonight? Everything about that was predicated on their site plan. Same thing in 1983. The scope of that variance, if you want to see what is this variance all about, you look at the submitted materials and you read the minutes if they're applicable.
I understand what you're saying, but I also feel like the fact that it was never built at all kind of calls the whole thing into question. It was, the variance was granted on the material submitted, which says we're going to build a garage. No garage was built for 40 years. Things change. I don't understand why we have to have strict adherence to this variance when the spirit of it all was never respected in the first place. 40 years have gone by.
Exactly, 40 years has gone by, and the past board acted on the plans that were before them. Now,
But the plans were
approving
never
that
moved
variance
forward.
could have exceeded the building area, we don't know. Or some sort of subsequent construction could have, we don't know. It's not, in my opinion, it's wrong for the board to speculate on what may have caused the building area to exceed 40%. What we do know is what the board in 1983 approved and the plans that they were looking at when they granted that approval.
But
Well, Stephen,
they
if,
granted the approval based on plans to build, and nothing was ever built. There's
Well, like I said
nothing was
earlier,
ever
you
built.
can-
The
you
spirit
can
of the
get-
whole transaction was not respected.
Like I said before, you can get a variance and never do anything with it. You don't ever have to take advantage of a variance if you don't want to.
We're just willy-nilly increasing our buildability on lots. Why would you be getting a variance to not build?
Well, perhaps you're going to flip the property. Perhaps you're going to shop the property. Or perhaps you don't have the funds that you thought you had to build that addition or whatever it was. And when you do save up the funds to build whatever it was, then you can do it then. Well, you know, but there is nothing in statutory or case law that I've ever seen that limits variances or puts a sunset on them. They simply don't expire.
well, Stephen, my point is, you don't need you got 5 feet off the property line, you don't need a variance for the structure, correct?
Correct.
So why can't you just come in for a variance for lot coverage? It wouldn't open up the whole can of worms because you don't need a variance for what he built.
Because you can deny, again, two things. A, this has already been decided in 1983. The board approved this project in 1983.
But he doesn't need that
Second-
variance.
And second, if we bring the homeowner in for an additional variance, you can deny it, which means something's got to go.
Gotcha.
And it could very well be something that they already have approval for.
Mr. King, go ahead.
Since the permit was reissued in November, shouldn't the lot coverage have been an issue then? Or you based it was based on the recent survey, and it was reissued on the recent survey in November 2nd, correct?
Yeah, yes.
And shouldn't the lot coverage have been an issue then, when we had the survey?
Lot coverage should have been an issue.
Considering we didn't know that before?
Lot coverage should have been an issue in 1983, but it wasn't for the past board. They approved this project without a survey, without a zoning table.
So you're saying is because they approved it without it, we can't consider it?
No, because it's already been voted on, it's been recorded. You can't reopen it. You can't reopen another variance.
But you were able to say that they were compliant on the second floor after you got the survey and reissued the permit on that, though.
The second floor is compliant now because they've chosen not to take advantage of the 3-foot variance that they were granted in 1983. If they wanted to, they could have pushed it closer.
All right, so you're saying even after the fact that you reissued the zoning permit, because it was granted before, you're saying that the lot coverage doesn't matter now, even though it was reissued?
If they had taken off the second floor and kept the first set of plans, I would have reissued the zoning permit because it would have been following the scope of the approval. The fact that they're actually 5 feet back and not 3 feet back means, and it's still attached to the house.
I
It's in a
understand
zoning
that.
compliant location, so they can have that second floor.
Because I'm just wondering, because the zoning permit was revoked and then reissued. This lot coverage issue doesn't come up with the reissuing of the permit, since the original one was revoked?
The building area does not come up as an issue because the variance was already granted in 1983 for garage to be 3 feet off the lot line.
Okay, well, maybe
Now
the
they're building
question I'm asking is that it doesn't matter that variance, that permit was revoked. That doesn't affect that variance in 1983.
No, the permit was revoked because the original plans showed that second story under the garage, which was not shown in 1983. So that exceeded the scope of the variance, that second floor.
Okay, so there's no effect on that variance from 83 by the fact that it was revoked, that the permit was revoked in November.
There's a lot of echoing going on in here.
I'm wondering is the variance that was granted in 83 affected by the fact that the zoning permit was revoked in July of this year?
I'm having a hard time following it, but let me just sum up. In 83, they approved a 13.5 by 23-foot garage 3 feet away from the property line with no consideration of building coverage or anything else.
Got that.
Then a zoning permit was issued based on those 1983 plans. And then we saw that the garage had a second floor. Well, that was not shown on the approved set of plans, therefore it was revoked. Then the homeowner had a survey done which showed the setback is 5 feet. That makes it zoning compliant, therefore they can keep that second story.
I understand that, but I just want to make sure I'm clear on it, that the fact that the permit was revoked in July of this year does not affect the fact that the variance was granted in 83.
Oh, no,
right?
no, that has nothing to do with it.
Okay.
Yeah. The only reason why it was revoked is because they exceeded the scope of the variance in 83.
Ms. Ferranti.
If the permit was reissued based on the survey that shows that the addition is zoning compliant based on location, then the variance is irrelevant. They're not using it. So why then are we not separately dealing with the lot coverage variance issue?
Because if you reopen this and you make them file for a building coverage variance, you can deny that, which means they have to remove something, and maybe the garage they already have an approval for, or perhaps part of the house. Or
The
perhaps,
approval,
or perhaps something else that's on the lot. See what I'm saying?
the approval, though, is irrelevant because they're not engaging the variance. There's two separate issues. The setback variance and the lot coverage variance become two separate issues if you say that the location of the addition is zoning compliant and you are not engaging the setback variance.
they're
Then they become two separate issues.
But they're really not separate issues, because the board has already approved that garage. And if you reopen this and you make them get another variance, you can deny that, and you're denying them the variance they've already been approved for.
Excuse me, Mr. Chairman. That's just flat out incorrect. In this, Ms. Ferrante is correct. They're two separate issues. You're relying on the survey to say, oh, now it's compliant and they don't need a variance at all, but forget about the lot coverage. So the survey's valid for one reason, but not valid for another reason. You're not ignoring or they have to do what everybody else does, comply with the zoning regulations and comply with the lot coverage. If they come in and they get approved, okay. If they come in and get denied, they have to figure it out. They got 2 sheds on the property, they could reduce the lot coverage in another way. But the lot coverage has to be addressed, and it should be addressed by a variance or a reduction in the lot coverage. Thank you.
Okay, we're all set with our questions? Yes? All set? All right. Okay, this hearing's closed. Okay, so your task is to uphold or overturn the decision.
I move to uphold the decision of the zoning enforcement officer in reissuing the zoning permit.
Second.
We have a motion to uphold, and we have a second. Discussion? Discussion, anything? You already know, you all have your minds made up? Okay. I'll take a vote. Mr. Soda,
I'm with the motion.
Ms. Ferranti,
Against the motion.
Mr. Montana,
Against the motion.
Ms. Hirsch.
With the motion.
I'm against the motion. 3-2. Mr. Harris, overturned?
Overturned.
Okay. That's the vote on that. All right, we'll move on here. 3-2. Going to ask him that question.
Stephen, I thought you had to have 4 votes.
No, okay. All right, we're all set.
The vote is,
Okay, it was overturned. All right, new business. We have some new 2024 calendars that you should have. That's all we want to say about that, Meg?
We need a vote to accept it and approve it.
Take a fast look at it, see if anything that might be a conflict of interest to you.
Voice vote will do.
Not that it's going to matter, you have to go by the calendar. We need approval?
Make a motion to approve.
Okay.
Calendar.
All in favor? Aye? Okay. Old business? Old business. Staff update?
I'd like to say a quick word. I see Mike Smith back there, and I would like to personally say it was a pleasure working with you, and best of luck at the Board of Ed. I'm very happy to meet Mr. King, and I am so sad that even though your successor will be no doubt very capable and wonderful, this is the last night. I will be elbow to elbow with the icon, the legend, Joe Tizzola. And here, here.
Well, thank you for that comment, and, everyone knows I've been doing this for years, and I want to thank all the, present and past commissioners that I've worked with to make all the time that I've done it pretty much successful, and this board has always been fair with the decisions that they make, and that's one thing I've always been proud of, that I haven't heard any bad comments about us in all these years, and I appreciate everyone that I've worked with, and it's been an honor to serve the city of Milford. Thank you.
Thank you, Joe.
Okay, so we had our staff update. Acceptance of the minutes from November 14th meeting.
Make a motion to
look
accept
good?
the minutes.
Seconded.
All right, all in favor? Any applications for next month? Do you have much?
I don't think we have anything yet.
I haven't seen anything.
Oh, you might not have a meeting in January, okay. All right, motion to adjourn? This meeting is adjourned.